Uh, my name is Mushahid Naqvi. I am a research associate and project coordinator at Center of Pakistan in International Relations. I welcome all the panelists, moderators, and participants on the behalf of COPAIR to our virtual conference titled FATF Dialogue Challenges for Pakistan in Combating Money Laundering and Financing of Terrorism. Center of Pakistan and International Relations is a strategic think tank dedicated to the study of defense, security, and strategic studies, and it seeks to promote an in-depth analysis of national and international affairs, especially the ones which thrives on the intersection of policy formulation and policy making. COPAIR initiates and advocates policies of national development in order to build a sustainable, inclusive, and resilient Pakistan. Our center aims to act as a platform for the engagement of foreign and local speakers and intelligentsia to discuss various national and global issues and provide policy recommendations. I would like to formally commence the session with the recitation of few verses of Holy Quran. Iftar, can you please play the video? Thank you. Jazakallah. Now I will introduce our moderators. Today we have two esteemed co-moderators for this virtual conference. Our first moderator is Barrister Abdullah Mumtaz Kahlon. He is a lawyer by profession with expertise in international law. He has practiced law internationally in the courts of England and Wales for 9 years, as well as brief stint at the United Nations War Crimes Tribunal at The Hague. He currently resides in Lahore and dedicates his time to legal practices. Our second moderator is Ms. Maleeha Hashmi. She is an investigative journalist and ex-media consultant with UN. She represents Pakistan on international media. She is also a motivational speaker. With this, I would hand over the forum to our distinguished moderators for further proceedings. Thank you.
Thank you. First of all, good afternoon, everyone. And I would like to thank the COPAIR and Ms. Amna Malik for organizing this seminar. And the topic of this seminar is the FATF Dialogue Challenges for Pakistan in Combating Money Laundering and the Financing of Terrorism. As some of you here already know, the Financial Action Task Force is an intergovernmental body that was founded in 1989 by the G7 countries to develop policies to combat money laundering. And after the 9/11 tragedy, its ambit was enhanced to include terrorism funding. A lot of countries then took significant measures to help combat money laundering and terrorism funding. For example, in the United Kingdom, where I have practiced for many years, the UK Parliament legislated the Proceeds of Crime Act 2002, the Terrorism Act 2000, that was later amended by subsequent acts of Parliament, the Money Laundering Regulations 2017, and then 2019. Similarly, in Pakistan, we were also ahead of the curve when the Pakistani Parliament legislated the Anti-Terrorism Act in 1997 to limit the financing of terrorism. In 2007, Pakistan issued the Anti-Money Laundering Ordinance, under which the FMU, which is the Financial Monitoring Unit, was created. In 2010, Pakistan further enacted the Anti-Money Laundering Act. Here in Pakistan, it's the State Bank of Pakistan, which is the central bank, and the Securities and Exchange Commission, which have always acted as the primary financial regulators. Other state regulators include the National Accountability Bureau and the Federal Investigative Agency, FIA, who have also assisted in enforcing the strict anti-money laundering laws in the country. Notwithstanding this raft of legal measures, it came as a surprise to many in Pakistan when they found their country being put on the grey list in June 2018. The country then undertook a whole range of legal measures to address this, some of which will be elaborated further in this webinar. Just to keep you guys apprised, in the plenary session of the FATF in February of last year, Pakistan was found to have made significant progress on 14 of the required 22 points. At the subsequent review in Paris in October last year, it was found that Pakistan had taken many reformative measures and had been able to address 21 of the 27 action items required. Later this month, Pakistan is once again to report to the Asia Pacific Group, which is the regional affiliate of the FATF, on the progress on the remaining few action items. In the backdrop of all this, it will be remiss of me not to mention that Pakistan has indeed played a vital role in the international war on terror, and as a consequence has suffered tens of thousands of civilian casualties. The direct and indirect loss to the national economy here has been over $100 billion. It is fair to say that the general mood of the Pakistani populace at present is that despite their sacrifices and losses over the past 2 decades, they feel a sense of betrayal when they find that their country is being listed in the same bracket as Syria, Sudan, Yemen, and Zimbabwe. What comes as a further sense of shock to them is that war-ravaged countries like Afghanistan, and indeed countries like India, where state corruption and money laundering is indeed rife, are conspicuously absent from the FATF grey list. One has only got to look at the recent expose in the European Union Disinfo Lab report, which was titled Indian Chronicles, a deep dive into a 15-year operation targeting the European Union and the United Nations to serve Indian interests, to get a flavor of the extent of India's involvement at the international level to undermine Pakistan. Now, having provided you all with this basic overview, I must add that in the course of this webinar today, we all hope to listen to the eminent speakers who have very graciously given up their time to address us on the topic or subtopics in question. And I must remind you all that if you have any questions, please do ask them at the end via the chat box after all the speakers have finished. And now I shall invite my co-moderator, Ms. Maleeha Hashmi, to invite our first speaker. Thank you.
Ms. Maleeha, please unmute your mic.
Sorry, can you hear me now?
Yes, please.
All right, sorry. So thank you very much, Abdullah. Thank you, Center of Pakistan and International Relations, for organizing this amazing webinar on this much significant issue. So in today's session, we'll try to seek answers to various questions involving the discrepancy of FATF's treatment towards Pakistan and India. We'll try to figure out as to why Pakistan and India are not being treated by FATF on an equal level, when clearly, as Abdullah clearly mentioned, and the whole world is talking about the fact that there are many irrefutable evidences of Indian involvement in terrorism which have been found, and everybody's talking about them except for FATF. FATF is turning a blind eye to India's crimes, and they're not holding India accountable for all of these crimes, whereas they're treating Pakistan very unfairly. Only recently we saw top US financial watchdog, US Treasury Department's Financial Crimes Enforcement Network. They shared in their recent report filed on 23rd September 2020, exposing the involvement of 44 banks involving, including India's own state-owned bank, which was found to be involved in money laundering of over $2 trillion US. And this money was apparently used for terrorism in the region. So this is quite alarming. In addition to it, suspicious activity reports also found that over 2,000 suspicious transactions between 2011 and 2017 took place, amounted to $1 billion US. There's a lot more to be discussed, and I'd like to open the floor by inviting our first distinguished speaker. Let's welcome Dr. Tehmina Aslam Ranjha. Thank you very much, Dr. Tehmina, for joining us. Let me introduce Dr. Tehmina to you all. She's an assistant professor at School of Integrated Social Sciences at University of Lahore and research fellow at University of Lahore Center for Security, Strategy and Policy Research. Currently, she's working on a mega project on countering violent extremism. She appears on BBC Urdu as an expert on national security and counter-terrorism. She's key member of Dukhtarane Pakistan and actively working for peace in Pakistan. Thank you, Dr. Tehmina, for joining us. Please, over to you.
Assalamu alaikum, everyone. Good evening, and thank you very much for such a generous introduction. I am thankful to President of Center of Pakistan and International Relations, Ms. Amna Malik, for the invitation to speak at this webinar, and I am thankful to Mr. Mushahid Hussain for inviting me. As this is a dialogue on FATF, so first of all, I will be speaking on FATF's concerns and action taken by Pakistan so far. I have recently written a research paper on this subject as well, that what are the concerns that are raised by FATF and what are the actions taken by Pakistan so far. So I think in this regard, the main challenge for Pakistan are the concerns raised by FATF. In February 2020, as we know, FATF declared Pakistan fully compliant on 14 out of 27 points, which with varying degrees of compliance on the remaining 13 points. So I will discuss them point wise. First of all, first point is related to effectiveness against terrorist financing. Number one is that to curb terrorist finances, Pakistan will have to demonstrate the effectiveness of sanctions, including remedial actions. It means that merely the process of imposing sanction was not enough, and the demonstration of the effectiveness of these sanctions was imperative. So this is that the sanction should yield some results. What FATF demands Pakistan, that the sanctions Pakistan has imposed, they should yield some results. Similarly, the remedial measures carried out should also bear some fruit. So in this regard, what action Pakistan has taken till now is that the Anti-Terrorism Act of 1997 laid down the basic legal framework for counter-terrorism prosecutions in Pakistan, and the Anti-Terrorism Act followed the parameters set by the United Nations Security Council Act of 1948 to include in its first schedule the organizations and its fourth schedule the individuals banned by the United States Security Council Act of 1948. So in this regard, the UNSC resolution 1267 was made obligatory for all its member states to implement measures of asset freezing, target financial section, and arms embargo and travel ban on both individual and entities designated on the section. Against this background, the Ministry of Interior in Pakistan divided the fourth schedule of the Anti-Terrorism Act of 1997 into three categories by classifying the proscribed person, organizations, and established standard operating procedures, SOPs, for bringing them under permanent surveillance regarding their activities and movements across Pakistan. Now, the persons, those who are placed on the fourth schedule, they are required to seek prior permission from the local police stations before moving from their residence for any period, and that they will have to keep inform the police about their whereabouts. So to this effect, Pakistan has proscribed 2 main and 11 affiliated organizations that are listed on NECTA's website. And the second point is that to curtail terrorist finances, Pakistan will have to ensure the better effectiveness of its financial institution against banned outfits and proscribed persons. It means that Pakistan should improve effectiveness of its financial institution, such as banks, against banned organization and proscribed person. So what action Pakistan has taken till now is not up to the satisfaction of the FATF. So here we are asked to do more. And third is again effectiveness against terrorist financing, to deny the flow of cash by personal reference system across the border. Pakistan will have to take disciplinary action against illegal money or value transfer services such as the system of Hundi Hawala. It means that all transactions should be done through financial, formal, recorded channels of transaction instead of the system that remains unaccounted for. So in this regard, action taken by Pakistan is that we have seen that on 27th March 2010, Pakistan had enacted the Anti-Money Laundering Act of 2012, and certain claims were made regarding its effectiveness. The implementation remained deficient against the Hundi Hawala system. In this way, still Pakistan is largely compliant on this point. The FATF, however, considered that there are deficiencies in AML's scoping of establishing offenses further regarding the regulation for designated non-financial business and professions. And fourth point is that to discourage the flow of cash by hand inside the country, Pakistan will have to place a sanction regime against cash courier. This is the main point that is raised again and again. It means that Pakistan should not tolerate the transfer of money in cash outside the banking system inside the country. So what action Pakistan has taken till now is that Pakistan has put a regulatory mechanism to discourage unrecorded and untraceable cash flow inside the country. The FATF considers that sanctions outside the banking sector relating to AMLF and CFT requirements are limited. Moreover, overall targeted financial sanctions are short of being disassociative. And fifth point is that to set an example, Pakistan will have to ensure bringing the ongoing terrorist financing, local investigation of law enforcing agencies against banned outfits and proscribed persons to a logical conclusion. What does it mean to a logical conclusion? It means that the investigation cannot continue for an unlimited period. Further, Pakistan cannot leave any ongoing effort not concluding. Pakistan has to produce results. So where we are lacking, we have policies, but implementation, we are waiting for some miracles during implementations. So Pakistan has to produce result on these points. Sixth is that to facilitate the process of accountability, Pakistan will have to ensure international cooperation-based investigation against and conviction of banned outfit and proscribed organization. So what does it mean? It means that Pakistan cannot shy away from cooperating with international bodies to investigate them. And what action till now Pakistan has taken? It is that the FATF considered that Pakistan lacks legal arrangement to provide mutual legal assistance in matters of terrorism financing and most predicate offenses. And next, seventh point is that to investigate terrorist financing, Pakistan will have to put in place effective domestic cooperation between the financial monitoring unit and law enforcement agencies. What does it mean? It means that Pakistan will have to establish an effective intra-country system of coordination between domestic institutions or bodies investigating terror finances. Institutions should not blame on each other that interior ministers say that it does not fall under our domain and other. So the time taking problem is the division are not, you can say, institution are not aware of this, that either they fall under our domain or not. So action taken in this regard is that Pakistan has put in place an intra-country system of coordination to investigate terror financing. The FATF underlines that there are no public procedure for the 1988 committee to review implementation nor for affected person. There is no legal obligation for all natural and legal person to freeze the funds or assets without delay. And eighth point is that to set an example, Pakistan will have to prosecute banned outfits and proscribed persons. It means that Pakistan will have to take legal actions against both the banned outfit and proscribed person. No such person and organization could be saved as being a strategic asset. When the state punish them, the link between the state and the bodies will be severe. So what action is taken till now by the Pakistan? The Interior Ministry banned 2 main and 11 affiliated organizations, as are mentioned on NECTA's website. And ninth point is that to set an example, Pakistan will demonstrate conviction of both proscribed persons and banned outfit from the court of law. It means that Pakistan will neither spare anyone under any rules. And what action taken in this regard till now is that the Interior Ministry has got more than 200 individuals related to the banned organization convicted. And 10th point is that to show the seriousness of action, Pakistan will have to seize the properties of banned outfits and proscribed proscribed persons. It means that the seizure should be legal. Either the courts will have to issue a verdict, or Pakistan's government should seize properties of such persons and bodies to discourage their followers and fellows from continuing with the same activities. So in this regard, action taken is that the Interior Ministry formulated asset freezing rules and froze 976 movable and immovable asset of the banned organizations. And 11th point is that to diminish trends in the future, Pakistan will have to take measures to convert madrasas to school and health units into official formation. It means that Pakistan will deny infrastructure to such persons and bodies by not only seizing their properties, but also converting these properties into some beneficial form, such as school and government offices. So what action is taken till now is that the Interior Ministry introduced the charity law of 2018 across the country. So 12th point is that to set an example, Pakistan will have to cut off the supply route of the funding of banned outfits and proscribed person. It means that Pakistan will have to Pakistan will have to obliterate the welfare work of such persons and entities run through donations such as alms and offering. So what is the action taken by Pakistan till now is that the ministry appropriated funds amounting to 2,400 millions meant for the management of the taken over educational and health facilities. So in this regard, the last point or 13th point is that to set an example, Pakistan will have to put in place a permanent mechanism for the management of properties and assets owned by banned outfits and proscribed persons. It means that the properties and assets which were seized and converted would be brought under a permanent mechanism of management. In this regard, there is not known that Pakistan has taken any action or not. So my recommendations in this regards are that Pakistan should take the help of court in sentencing those persons, and Pakistan should conclude further investigation. And there are few points there we need to do more. Thank you very much.
Thank you very much. Thank you, Dr. Tehmina. That was very insightful of you. Thank you very much. So before we invite our next speaker, am I being heard? Okay.
Yes.
So before we invite our next speaker, I'd like to again emphasize the fact that FATF's attitude towards Pakistan and India is clearly very discriminatory. And this needs to be looked into. I mean, Pakistan has to institutionalize lawfare and devise its central legal framework in such a manner. I mean, Pakistan's legal strategy has to be framed out in such a manner that its national security goals are achieved more easily. Pakistan's national security framework is also strengthened. So let's call our next speaker, Mr. Ehai Eric Esoy. Pardon if I mispronounce your name, Mr. Eric.
No problem.
Am I pronouncing your name right?
Yeah, it's all right. Yeah, you can use Eric. It's cool.
Eric, all right. So, Mr. Eric, thank you very much for joining us.
Thank you.
Ladies and gentlemen, I'd like to introduce Mr. Eric to all of you. Mr. Eric is an author and lawyer by profession. He's authored more than 30 publications, including 7 books on money laundering law and banking law. He received a bachelor's degree in law from the University of Lagos and holds a master's degree in international banking law and anti-money laundering compliance from Cardiff University. He's the managing partner of E4 and AAF, a global consultancy firm that also offers training and education to financial institutions on anti-money laundering compliance. His area of specialty and expertise is in countering financial crime. This is categorized into regulatory law, substantive law, and professional compliance guidance in terms of strategic management of money laundering risks and vulnerabilities. Thank you very much, Mr. Eric, for joining us. Please go ahead. Thank you.
Yeah, thank you very much. Thank you very much to the president of COPAIR for the invitation, and also to Mr. Ali. I would like to share my screen so that I can kickstart my presentation. Yeah, I think is my screen showing?
Yeah.
Yeah, okay. Yeah, okay. All right. Yeah. Thank you very much. So I'll be presenting on the subtopic called the implementing the preventive measures of recommendations 10 to 23 of the Financial Action Task Force using a hybrid of rules and predictive models, the case of Pakistan. So that is exactly what the presentation will be like. Trying to move my, okay. Yeah, so this is the table of contents. We have the overview. I'll try to give an overview of the preventive measures of the Financial Action Task Force. Then I'll go to the challenges for Pakistan in implementing the preventive measures of the FATF. It will be done briefly because a lot has been said about that. Then I'll go to the recommended actions. I would focus on the hybrid approach to this. Now, going on to the overview of the preventive measures of the Financial Action Task Force, the aim of me looking at this is just for the viewers to just just get an understanding of what we are kind of talking about in terms of the compliance level. So I'm more concerned about the preventive measures for now, so that it looks more proactive in the discussion. So when we look at recommendation 10 or customer due diligence, when we look at customer due diligence, I'm just trying to make it easy to break it down into 4 different parts. The first part that it actually talks about the customer due diligence is that it requires the collection of information from a particular customer, enough information to establish the identity of the customer, so that the customer, you're able to know the customer very well. The next step is the identity document verification. So once you have collected information from the customer, probably you use an application form to do that. Banks use application forms, or probably another method of just orally asking questions. Okay, what is your name? What is your address? You have to ask the person to produce documents, probably a government issued ID card, the passport. So that's what you call the identity document verification. So you need to verify the documents, and the next stage is identity data verification. So the data in the what is there in the government issued ID card, you want to actually verify the data. So you have to compare the visible data, which is around the photo, the information on the photo, with the MRZ, the machine readable zone, so that you can see whether it is actually authentic. So that is exactly the next step. So after you have been able to do all these comparisons, then you have to actually screen the customer using probably a global watch list, a sanctions list, or a PEP database, to be able to classify your customer, whether it's under to know where the customer falls on, whether it's a high-risk customer, low-risk customer, or a medium-risk customer. So if the person is a politically exposed person, then you know that you have to classify the customer as high risk. So going straight up to record keeping, you just have to keep records of the customer due diligence, as I've said, is kind of like the bedrock of what everything else I'm going to say. So it's going to move quite fast because the record keeping, you must be able to keep records under recommendation 11 of all the information you got from customer due diligence, and also the documents, you must keep records of that. And it has to be at least 5 years, even after the end of the business relationship or occasional transaction. So it's very important. For recommendation 12, we have politically exposed persons. Financial institutions are required to ensure that they do their due diligence properly. Now, the only way you can even know that the person is a PEP is after you have actually done your due diligence at recommendation 10. So once you do your due diligence at recommendation 10, a standard due diligence, you'll be able to know who the person is, and then you classify the person as politically exposed persons. Then you apply your enhanced due diligence to know, okay, what's the source of income, the source of wealth, using a lot of information to do that. So politically exposed persons are individuals entrusted with prominent public functions. And you have like the head of state, prime minister, anybody that is probably subject to that. But you have different types of PEPs. You have probably primary PEPs and secondary PEPs, but that's not really. Then recommendation 13, we are looking at correspondent banking. So you have a situation where, just like customer due diligence, it's a little bit more about doing the due diligence and institutional due diligence, where you have a correspondent bank trying to get so much information from the other bank that's actually helping to supply services. So it's actually needs to know, because the bank is using the services for other customers. So it's very important, and they have to apply, when necessary, the enhanced due diligence measures. For recommendation 14, we have situations where we look at the Hawala, the Hundi, the Chiti, when they came up at first, that is what now led to this issue of the money or value transfer services. So these are people that they're actually out of the formal system in a way, the banking system. So you have them that the FATF has recommended that it's actually, you have to license them or you have to register them, either one of the two. So you have to pick one of those. Recommendation 15, we have new technologies. Now we have financial institutions that go ahead and offer products and services. So, you might start offering mobile banking services. So if you offer mobile banking services, you have to be able to assess the risk of your product, because it's possible that, okay, what's the geographic risk? Where is the product going to? Like, what are the customers you're going to use? What is the quality, the characteristics of the product? So the more the characteristics of it, so if the product has characteristics where you can do so many things with the product, you can do a lot of online transactions, the risk goes high. So you must have mitigating measures for that. For recommendation 16, we have wire transfers. This happens electronically. And if you look at the fencing files, when we had a lot of banks, big banks in the United States involved in that, you see that there's a lot of wire transfers that happened with the fencing files. And there wasn't any, normally you have to have the information of the originator and the beneficiary. Many of these banks didn't even carry that. And it is something that you have to do. So the wire transfers must have the recipient, the beneficiary, and it also has the originator in it. Now we go to recommendation 17 for reliance on third parties. People rely on third parties for due diligence. It's so important, because sometimes you use commercial organizations to do your due diligence. Now what the FATF is saying is that you must ensure that you assess the risk level of this particular commercial organization. You might also use them for certain other things, like if you are doing like independent testing, you must know who you are trying to test there. Regulation 18 is going to the internal controls. A lot of institutions have internal controls. They are like like having a customer identification program, a customer verification program, record keeping, suspicious transaction reporting programs, training programs. These are what you call internal controls. You must have them in place. You must also have independent testing in place. Recommendation 19 is about high risk countries. You are able to assess the risk of high risk countries. You can get that so many ways through the mutual evaluation reports. You can also get that through the even Transparency International, knowing that the countries they are under high risk. Recommendation 20 goes to the reporting of suspicious transactions. When a transaction is suspicious, it has to be reported. If you suspect, it has to be reported promptly. So a country must know what to classify that as. What you mean by promptly? There are countries that use probably 24 hours, or countries use, depending on the situation. Recommendation 21 flows in from recommendation 20, talking about tipping off and confidentiality. What it's saying is that financial institutions, some of them are on the habit of trying to tip off their customers, like making them know what is happening. Like, especially when you have reported to the financial intelligence unit, you're not supposed to say anything. So that's what it calls the tipping off. So there must be laws in place, provisions for this. I believe that Pakistan has done even a lot in this, complying, they call it technical compliance, but we are going into the issue of the effectiveness. So there must be confidentiality. Then we have recommendation 22 and 23. Yeah, going back, when we go into this, we know designated non-financial businesses and professions, but I think Pakistan recently took a big step from what I saw. They actually had regulations for designated non-business and professions. I think what the FATF was saying was that there were no penalties. So I don't know how far that has gone. Now, going straight into the challenges for Pakistan in implementing the preventive measures, we have the first one of the insufficient understanding of money laundering and terrorist financing risk, anti-money laundering and combating the financing of terrorism obligations, and application of risks mitigating measures. Now, what that means in essence is that, not to break it down, it is not as if it's everything that's like that. From what we've seen, banks, and what it's trying to say is that banks and exchange companies displayed a limited and mixed understanding of terrorist financing risk, but they actually had an adequate understanding of money laundering risk. And overall, according to them, banks and exchange companies' application of money laundering and terrorist financing mitigation measures is undermined by limitations in the risk understanding, particularly for terrorist financing, according to them. But I'm seeing well in these challenges that banks kind of doing well to an extent. I think the biggest challenge there was going with non-bank financial institutions and Pakistan Post, Central Directorate of National Savings, and designated non-financial business and professions. Those three, according to them, but like we said, regulations have actually been put in place recently. So when the evaluation is done, I'll be expecting some form of adjustment. But for now, based on the 2019 mutual evaluation reports, we saw that the banks were kind of doing a little bit well, and we saw that it happened with non-bank financial institutions mostly that had a lot of challenges. And we also saw issues going with Pakistan Post Central Directorate. The other thing there is that there was limitation, another challenge, the limitation in the effective application of customer identification and verification measures, and ongoing due diligence with deficiencies related to beneficial ownership. What we saw also in that, because I'm trying to categorize it into different ways, is not that Pakistan didn't comply to we had most banks, according to them, effectively applied record keeping requirements for CDD, and they had risk-based customer due diligence policies. But the problem, according to them, was a significant deficiency is their lack of effective identification of beneficial owners. It's so important. Even in the FinCEN files, we saw issues like that. Beneficial ownership is becoming so important. Like, it seems to be the bedrock of everything, like trying to shed off shell companies and ensure they don't do what they're meant to do. But going back again, you see that they said most non-bank financial institutions, most of them understand their CDD, but those reporting entities implement those obligations on a rules-based approach. It's very important, a key word here, rule-based. So what they're trying to say is that, yeah, it's not as if they don't know everything, or they are doing it like that. What they are saying is that they are not doing it because it's supposed to be risk-based, according to the FATF. That's the standard. So to them, they are using the rules-based. So risk-based normally is supposed to be like doing 3 stages. It's a comprehensive approach to mitigating money laundering risk, going in 3 stages: identifying the risk at the customer due diligence stage, assessing the risk, at the enhanced due diligence stage, and taking measures to mitigate the identified risk at the enhanced ongoing monitoring stage. So that is exactly what they expect of them in terms of doing all these particular things. The third one is the limitation in the effective implementation of enhanced due diligence measures. According to this, we see that most banks apply EDD measures for PEPs, correspondent banking, new technologies, targeted financial sanctions. But for larger non-bank financial institutions, they have EDD, STR procedure, that's suspicious transaction reports, and use systems to screen for PEPs. But all other non-banking financial institutions lack proper systems to identify PEPs. And that's exactly what was said there. And they also said that just the same thing, designated non-financial business professions, Central Directorate of National Savings, Pakistan Post, do not apply enhanced due diligence measures. So it's still an issue of we're having banks doing very well to an extent, but all these people like the Central Directorate, Pakistan Post, designated non-financial institutions, they're not really, so to them, they feel that was one of the major reasons why they gave the rating what it was. Then we have the issue of late filing of suspicious activity reports and low quality SARS. We have the issue of, in this particular instance, it says banks and exchange companies report suspicious transaction reports. Yes. However, their reporting is undermined by lack of information on MLTF risks. STRs are not filed promptly, and reporting related to terrorist financing is not consistent with Pakistan's risk profile. Therefore, non-bank financial institutions, they're not filing also their suspicious transaction reports commensurate with the money laundering risk in these sectors. And the Central Directorate of National Savings, they are yet to file, but we are hoping that will change. There's a regulation now, like I said, that would actually change. Pakistan has done well with issuing the comprehensive regulations. Now, we're also seeing the part of the failure of reporting entities to implement adequate policies, procedures, and internal controls based on appropriate assessment of their money laundering, terrorist financing risks. And in this particular instance, we see that banks are implementing internal controls. They're actually implementing it, and they're screening new stuff. But it's also a problem, like I keep saying, non-bank financial institutions not really doing well, and designated non-financial business and professions also. So I think that's one of the major challenges there. We are seeing banks doing a lot of, a lot of things, taking a lot of big steps, but going forward, that is not what we see. So I'm now going straight to the recommendations because this is what is key here for me to really emphasize. But before starting the recommendations, I just want to make a emphatic point, which says that just because of the fact that what I'm going to be recommending is a hybrid approach. Before I start from number one, a hybrid approach. And when we say hybrid, it's like I'm looking at the practical stuff, because what I reviewed now was effectiveness, not just technical compliance. So for me, what we're looking at is a hybrid approach. And the reason is that we're talking about combination of traditional rule-based systems going together hand in hand with something like artificial intelligence-enabled systems. We're talking about being able to comply with the recommendations, preventive measures, combining both of them together to ensure that everything is done effectively well. And that's just mostly about it. So let us go straight to the recommendation one. It says training for anti-money laundering compliance using focused classroom training, online training systems for higher risk or minority areas. What this means is that, that's the combination I'm talking about. Now, this one, you can do classroom training, you can do online learning systems. Now, how do you know which one to do? The best one for the financial institution is to be able to look at the fact that, okay, how many staff do I have? If you have a lot of staff, where are they at the moment? Many, so you have some that have a lot of branches. And so depending on the level, depending on the situation, depending on the product and services being offered, you have to be able to detect whether or not decide whether or not you are doing classroom training, or you can even do both. So that's exactly what we're talking about here. But the training should be on technology innovations. What is happening now? The staff should be able to use technology, should be able to use digital technology, should be able to use traditional rule-based systems, softwares to be able to screen customers, softwares to be able to verify the identity of customers. That's exactly the training. Then also be trained on using traditional rule-based systems also, like, robotic process automation systems where you can automate emails, automate filings and everything else. Number two, verify ID documents and identity data of a person using manual verification and automated authentication with facial recognition algorithms. Now, what this means in essence is that normally, depending on, and going back again, most of these things will also depend on what the regulators are saying. We have some, like for Canada, for example, Canada is going to say that, you can use software, you can use online systems to do all this. But you have some countries, even the United Kingdom is like, okay, before you use some kind of software, you must do it on a risk-based level. It's not just to just jump on the automated software. Traditional might be good for you, but so that's just going back to understand that, it's not always about AI. Now, looking at the issue of verifying ID documents and identity data, it can be done manually. Now, the manual system is that the person comes to the bank and, you collect his information, CDD information, okay, who are you, your name, and you take his document and you look at the document and you compare the information in the document with what is in the machine readable zone of the document, and once you do that, you can be able to verify that, okay, this is authentic. And you also use templates, the person that is doing it must have been trained. But the problem with this is that if you're in a country where the fraud level is very high, you might want to go to automated authentication, where you are just allow the machine to do the work for you, because it might be that the fraud level is so high that even if you decide to even if you decide to go with manual verification with using a human being, and also you also look at the level of corruption. If you have a situation where you know that a lot of the bank staffs are being corrupt, or the countries like that, it's better that the AI does it. Because one thing about AI is that it's so difficult for somebody to just infiltrate the system, except it's actually combined with also rule-based systems. So they can do that. But if you are using an automated verification system, I'm suggesting end-to-end ID document verification solution. And what that means, powered by API, application program interface technology. What that means is that you have a situation where you have a front end and a back end. So like, and the reason why you also use that is that, let's say you're a financial institution, you're offering some different kind of services like banking, mobile banking services. You know that you can't just, it's not everybody that you're going to see. You can't just be using human beings to do all the verification. You need to be able to balance this out. You have to be able to, because of the fact that the person is not there at the moment, you can't tell everybody to come in, you need them to apply for the mobile service. So they have to go in terms of the, they go to your website, they see that. So when you use the end-to-end, when you use the end-to-end verification solution, you can be able to do this. So what the end-to-end means is that you have the front end where the user interface is there for the ID document verification. You have a built-in image capture functionality, and you have the back end where the document images and selfies are submitted to an ID document verification provider that performs it. So it's amazing. But the technology that happens there is that you have an exchange of information. And what does the exchange is the API. So that's exactly the interesting part about it. Now, going to number 3, we have completing. You have to complete, even after you've done the ID document verification, you have to also go ahead and complete the anti-money laundering check of a person through politically exposed persons. You can use humans and software. If you're using humans, it might be taxing. So, but it also depends on how many customers you have. If you have so many customers, you can't be using humans. So I'm just trying to make people understand that the hybrid approach is a combination of selecting something else. So if you're using it like this, you might want to use something like, because if the humans do it, they might want to go into the website and they might check in on Google. Okay, is he a politically exposed person? Or is he, but if you kind of use a software, but you're sure about the software and the service provider, you can be able to do all these particular things. And it's still similar to what I said, the API technology, application program interfaces will be used. Verifying a company's vitals through documentary evidence and electronic evidence. Yeah, this is something that even we see a lot. Documentary, the vitals are just like registration number, name of the company, address of the company. Those are the vitals. All those things can be verified using documentary evidence. Like, for example, some people say, okay, submit documentations of your company from something that's supposed to be from the government register. So that is what you call doing it in the documentary way, like submit it to the banking office. But in a situation where you have, like I said, the product and service, you have like mobile banking, you have like prepaid cards, you have a lot of different online services, you might not be able to go in that direction. You might want to decide to go with electronic evidence. At the same time, even regardless of that, you might want to still combine if the risk level is high, if the fraud level is high. So what's the selection will depend a lot on what we see. Now, recommended actions, again, we have completing an anti-money laundering check of the business through PEP, sanction, and that is, and what we're looking at here is the business itself, the business, the company, compared to the individual. So you can complete the check using the application program interface API, or you can also use the humans. There's not, it's so also possible. They can check through the website. They can actually check the information. They can know to know what is up there. Or you can use a software to do that. You can use a software to screen a particular customers. And the amazing thing about the software is that, like I said, if you have a lot of customers and you have a lot of products and services, that's why you see that the FATF is like, technology. They have to refer to that. So it's very essential that if you have technology, you need to know the system and controls you are using. It has to be something that is commensurate with the level of risk of the product. So that's why what we're looking at here is something about you must be able to check this business through that particular software. So if you're having a lot of product, but if you're a company that is actually small size, medium size, and you're not doing much, you might not want to go into software or something. Then the other part is about number 6, identifying the ultimate beneficial owners of a company. manually using the official company documents and artificial intelligence. In this particular instance, there are a lot of software companies that do this. And what you see here is the fact that what they use is optical character recognition combined with natural language processing, and also, it's also powered by deep learning at times. And what this thing does is that the OPC, optical character recognition, extracts the information from the documents to be able to send it off to the service provider so that they can actually verify from that particular document what is there. And many of them have access to government registers. But one thing that people must be careful about is that an AI, artificial intelligence system, is as good as the data supplied to it. If the software provider doesn't, and it also depends on the country. Like, for example, if you look at what happened in the UK with the fencing files, you see that over there was a lot of issue with the company registers until they recently took some kind of measures to say, okay, you have to provide beneficial ownership. Same thing with the United States, that has been so popular. It was just now that we saw the step being taken that, okay, your company, once you are registering, we must know the beneficial owners. So the thing about it, all these particular things, is the fact that it is so important to be able to identify these beneficial owners. But you can only do that with the support of the country. If the country does not have online systems in place, it doesn't have a comprehensive government register, it will be difficult for, no matter how good the AI company is, artificial intelligence company, they will not be able to have enough data to help, because it has to be something like that. So they must be able to partner with the country. So if for example, like we were hearing from the systems in place of the UK, US in the past, and okay, this is what we want to do. And the fact that, and you ask yourself the question, what was the software, how was the software operating? Because if the software is trying to get to verify a particular company to get the beneficial owner of the company, and the source it's using is kind of just, it's kind of empty. It is not saying anything about what is there, then it's as good as not. It's better you even use a traditional system, to identify. So it's so important about that, referring to the fencing files. Number 7 is using manual processes and latest technological innovations to continuously monitor customer and counterparty risk for changes such as updates in global sanctions, PEP status. Now, this is so important. This is what they call ongoing due diligence. And what it means is that even if you've onboarded a customer, you have to continuously check for the level of risk of the customer. The customer risk can change. Like, for example, somebody coming in as you give the person says, a doctor, I'm a doctor, and you give the person a level, whether it's a medium risk, and say, okay, you're a medium risk customer, so I don't have to do that enhanced due diligence I have to do. It gets to a point where the customer might become like a politically exposed person. And maybe he gets a job at the, somewhere with the government. So the aim of the ongoing due diligence is so important. We've seen a lot of people being sanctioned for this, by a lot of financial intelligence, enforcement authorities. So you have to do the due diligence. Now, the thing about it that if it's done manually, it can be so difficult and draining, because when you have, just like I said, if you have a lot of customers and you are doing manual due diligence, it's going to be like you're going online every minute to check. Now, the suggestion there is that you can use RPA, robotic process automation. What happens is that if you have a software that is powered by the RPA, it does it for you. Like, we have a lot of softwares around that just checks the net, the internet, and also screens the customers every night. Like, it does it every night. It's just screening the customer. Okay, is the person becoming a PEP? So if once there's an issue, it just notifies you, okay, this person is actually a politically exposed person now. You have to change the level of risk. Now, in terms of number 8, using a powerful fraud analytics engine, embedded artificial intelligence and machine learning techniques combined with traditional methods to spot more suspicious activity. Now, what is this is that if you see there are a lot of people that have been fined on this issue. It also goes back to the fact of what is more appropriate for the company. If you have a rule-based, you can have a rule-based system of monitoring where it's programmed with rules. What is that? We call it traditional programming. Traditional programming is in the sense that it was coded with rules every step of the way. The program was created by data scientists or human. But the problem with that is that if you have a high volume of transactions, millions every day, and you're in an institution where your risk level is so high that the criminals are so smart, because the thing about rule-based systems is that most of the time it's not more than 200 rules that have been programmed in it. If you have 200 rules and you have a criminal that has outsmarted the system completely, then there's a big problem. And you can only know if you continue to audit the system to know what are the number of false positives, what is going on. So that's exactly where the whole challenge is. So in this particular situation, it will be better if you go out with a particular fraud system that can actually go with unsupervised machine learning, not even supervised. When you say unsupervised, it's not just, you can go with supervised also. But like I said, it also depends on your level of risk. But you can go unsupervised is so good because it actually identifies trends. It identifies common patterns in transactions. So no matter if somebody is, if you have millions of transactions and somebody is doing something different, the person will be identified. Now, going to number 9, adopting manual processes for suspicious activity reporting or embracing automation to handle it. This is just what I said, robotic process automation. You have robotic process automation that automates certain things for you. Now, you have a lot of situations where the fraud detection system has identified a particular suspicious activity and flagged it off. What will happen in this particular instance is that some softwares allow to automatically handle the situation. It can actually file it for you with the authorities. It can actually, without you even doing anything. But that situation will only happen if you know that the system, the country allows for online filing. If there's no online filing in the country, it becomes very difficult for you to say you want to use a software that does robotic process automation. It just automates like the moment, and it does it in a way that even when they flag off transactions, they will flag off it in designated, like they'll say, this is a high-risk transaction. This is a low-risk transaction. So it automatically, you can program it in a way to say, oh, this is high risk. Immediately, it does this automation. Now, that's exactly what goes on there. Now, the last part of it is fostering a culture of compliance. This is so important, which includes an external independent reviewer, AML program report, training plan, salute back. This is so like a lot of cases of people being fined, financial institutions being fined. This is exactly what we see. The culture of compliance usually is very weak. Like, and what we mean by that is that I've seen it. There was a case, against a US bank, I think by the FinCEN, that went ahead to go, and the bank, they had strong systems, AI systems, but what the directors did there was to try to change, try to auto-tune it in a way that it was capped at a particular level, so that it didn't have to bring out enough suspicious activities. So that's a very, very, very serious issue. So if you have a system where the culture of compliance is very weak, we're going to have a very difficult situation. So you need to have, one of the recommendations is that you have an external independent reviewer that can review your systems to determine if that system is actually comprehensive enough, and also look at the fact that how many false positives do you see? You have to review it regularly. Then you also have the program reports, that the AML program report that looks at what has been going on. You just to look at the situation, and the training plan about how often are training delivered, and what type of training is being delivered. And just like what we talked about, is it on technology? Do we have technology delivery and what have you? Then we have the SAR look back. You look back on the SARs that have been filed before, and whether or not there's need for any form of adjustment. So that's exactly where the recommendations are. It's just a matter of having a hybrid approach where you kind of know when to use traditional rule-based systems and also when to use artificial intelligence enabled systems, which we call predictive models. So my own conclusion is that you use robotic process automation, which they call traditional programming, where it is for repetitive tasks. When you say repetitive, because it's programmed with rules, it's better financial institutions use it for just a repetitive task that doesn't require too much thinking, doesn't require decision making. But if you want to make a decision, because we have softwares that can actually risk rate customers, if you want to make a decision, you have to use machine learning powered algorithms. That's exactly what it is. You must use that. So what I've just been able to talk about now are just the practical stuff that have to be there. And the Pakistan authorities can't do this by, making it part of the guidelines to say, okay, and probably explaining it more. This is what they can do. Then people can then try to make the system easy to happen. Like if you make it online, then everything is online. It's easy for the financial institutions to do so many things. So yeah, thank you very much.
Thank you very much, Mr. Eric, for your insightful discussion. Ladies and gentlemen, Mr. Eric enlightened us on how preventive measures of FATF recommendations can be implemented using hybrid of rules and predictive models. Thank you very much, Mr. Eric. Our next speaker is Ms. Kelly McCann. She's a financial crime expert with over 15 years of extensive experience with numerous multinational banks and countries on an advisory basis. Most recently, she's provided advisory services to APG, Asia Pacific Group, on how US financial institutions have implemented FATF recommendations. She's also worked with the Angolan government, teaching a workshop to central bankers on how to renew relationships with foreign financial institutions as correspondent banks. Currently, she's serving as a country risk expert for Euro money country risk and providing guidance to a Japanese bank with international operations on how to upgrade their policies and procedures to meet global standards. Previously, she worked for the World Bank and United Nations. She's also lived and worked in Russia, Russia and Switzerland. She studied international economic development and Russian studies at Columbia University in New York. She's an ACAMS member. She currently resides in the US. Thank you very much, Ms. Kelly, for joining us. The floor is all yours.
Thank you very much. And thank you to the organizers for inviting me to participate in this webinar among such a distinguished and accomplished group of professionals and policymakers. It's quite an honor. And thank you for organizing this very important webinar on this topic. This topic is extremely important and one that I hope to add some expertise and create some positive change. As was mentioned, I have a lot of experience working with multiple multinational financial institutions, both with domestic operations in the US and parent companies abroad. And during my experience, I've learned that money laundering, combating money laundering and combating terrorist financing is a challenge to all of the financial institutions and all the countries that are involved. Money laundering and terrorist financing are serious crimes around the world. And if successfully executed, the repercussions could have wide-ranging damaging effects, specifically national security. So it's a very serious situation globally and is not immune to any country, and they're all challenged with how to combat this situation. There's regulatory crackdowns around the world, specifically, as you know, with FATF and other regulatory agencies to create recommendations and guidance to combat money laundering and terrorist financing. And as a result, there are many violations that have been identified and penalties implemented to crack down on some of these violations. Specifically, a French bank, had violations with sanctions in Sudan, Iran, and Cuba. There is another example of a German bank that was fined several times in connection with Russian money laundering in Russia. So it's around the world, and it's not specific to Pakistan. It's not specific to any region around the world. It's global. There's an Economist article that I would like to share with you after the webinar that I find really helpful in understanding how this affects correspondent banking. And what I'm going to speak about today is correspondent banking, de-risking, and the money laundering effects with correspondent banking. The Economist article was written in 2017, and it talks about how many banks around the world and in various different countries were de-risked. And de-risked essentially means that the correspondent banking relationship was ended as a result of the fact that the correspondent bank believed that the respondent bank did not have enough AML and terrorist financing controls in place and were mitigating any risks were not mitigating any risks that were related, and that their AML BSA program was not effective enough. So as a result, the decision was based on the fact that the revenue in doing business with the respondent bank did not offset the cost of compliance fees in working with those banks. So as a result, in 2014, 2015, there was a significant de-risking going on around the world. And the Economist article points to a significant reduction from 2011 to 2016 in dollar transactions. There's a financial stability board, a graph that provides a visual to this effect, and it talks about how the number of correspondent banking relations fell in all regions between 2011 and 2016. According to a survey of banks and payments data published on July 4th, this Financial Stability Board, a group of international policymakers, provided the graph, and the worst hit was actually Eastern Europe, and saw a decline of more than 20% of their correspondent banks being de-risked. The number in the Caribbean fell by 10% in 2016 alone, and money transfer firms and charities were also hit. So again, it's a global phenomenon. It's not specific to any jurisdiction. Another area that's really suffering as a result of the de-risking are charities. And charities have been hit by the relief that they're providing to these humanitarian groups is not reaching because they've the funds are either taking too long to arrive as a result of the fact that so few banks are no longer doing business with the charities, or that the compliance and controls that are in effect take too long to implement, and then also to enforce that the money that's actually intended to reach the humanitarian relief groups is not reaching them. So clearly there's some progress that needs to be made on renewing correspondent banking relationships and determining how they can operate effectively and efficiently in this environment. There's a lot of guidance on correspondent banking that FATF provides, as well as other groups such as the Wolfsburg Group and the UN and the Office on Drugs and Narcotic Trafficking. Correspondent banking relationships are very important and vital to the global payment system and vital to international trade. Pakistan is an important player in an international trade and considered by many countries around the world as a partner, including the United States. The global economy as a whole, including emerging markets and developing economies, are relying on the correspondent banking relationships. But they're all subject to anti-money laundering and counterterrorism financing measures. And FATF recommends, the recommendations by FATF require financial institutions to identify and manage the risks associated with these business relationships and apply specific due diligence to these cross-border business relationships. So as a result of that, there's advice that I would offer to any banks that are interested in either developing or continuing to maintain a correspondent banking relationship. And I think the most important aspect would be training. So from my experience, I've noticed that the policies and procedures are on the books. They're available for anyone, any compliance officer within the bank, whether it's a central bank or a public or private bank, to read and agree that the policies are available for all to follow. However, I think that the difficulty is in the actual implementation of the policies and procedures and the knowledge of how to execute on them, and really identifying how to do an investigation, or how to onboard a customer appropriately with regard to regulations and the laws. So it's one thing to read a policy, but it's another thing to actually implement it. So one of the things that I've worked on with APG is explaining the FATF recommendations, and in the explanation of the FATF recommendations, then providing examples of how to implement each recommendation. So I think the disconnect really between those banks and the financial institutions and countries that don't necessarily have a high rating on their effectiveness of their programs really is the implementation of the recommendations. Not that they don't have the policies and procedures listed and in place, it's just really the knowledge of the individuals that are charged with really carrying out these policies and procedures, how to implement them. So the gaps that lead to de-risking are many. And so the causes of de-risking, as I explained earlier, have been studied by international financial and development communities. And there's numerous reports on the fact that this is global in nature. Studies by the World Bank and the IMF and others have provided insight into the drivers of de-risking from a global financial system perspective. Some of the risks that are associated and exist around the world, again, are the lack of processes, policies, and procedures. And once those are in place, then the understanding really is important to identify, to make sure that the individuals understand what needs to take place. And so the tone at the top, the culture of compliance, is extremely important. It's an imperative for the directors and senior management to fully commit to an AML and CFT compliance. And there's 4 pillars to an AML BSA program that need to be implemented. And those pillars must be in place in order to receive an effective rating. So that would be one area where a potential correspondent banking relationship would first look to determine if they would be interested and willing to engage in a correspondent banking relationship. So weak and ineffective KYC and CDD onboarding procedures would also be a red flag for any correspondent banking. So my recommendation again would be, more in-depth training with the individuals that actually execute the onboarding procedures. And it's not necessarily those that are high-level executives. They're, in general, they're more junior, even mid-level professionals that really are responsible for doing the investigations and submitting the SAR reports. That's another item that would be important to ensure with regard to training, is that the individuals that are doing the investigations understand how to conduct an investigation, how to write a SAR report, what a SAR report is, and what the reason for submitting the SAR report is. What the reporting process is, what the timeline involved in submitting a SAR. And lacking this knowledge can have severe repercussions. Another area that a correspondent bank would look at for a relationship with a respondent bank is the appropriate level of staff and resources with regard to whether they're manual or automated resources to make sure that the AML CFT function is operating effectively and has the appropriate tools to conduct the investigations, the onboarding, and all the associated and required areas that need to be implemented for a sound AML BSA program. And then the education and training component is also, as I mentioned, imperative. Other areas that should be addressed are ensuring that the internal controls are in place to mitigate any potential areas that are high risk for that specific organization or financial institution. So conducting a risk assessment, an institutional risk assessment is important, and in so doing, understanding how to do a risk assessment, the methodology behind the risk assessment, and once the risks are assessed, then the action plan, how to mitigate the gaps, what to do, and where to go from there once the risks are identified. Establishing a risk appetite and risk thresholds, and as far as the correspondent bank is concerned, determining what level of risk they're willing to accept in order to do business with the respondent bank. And creating a risk-based approach and a rules-based approach to implementing this program. It's important, as the previous speaker, Eric, mentioned, is incorporating document retention, record retention, so that previous information can be accessed easily. And creating screening and appropriate software in place to identify customers and determine whether or not they're a PEP, and determine where their source of wealth and income is, and really know your customer, the KYC acronym, and to understand really what the level of risk is with the customer, as well as doing a risk rating on the products and services that the organization offers. So there's a multitude of areas that really should have in-depth training within an organization, within an institution, in order to establish and maintain correspondent banking relationships. So in summary, I have some recommendations for some bank, whether they're a financial institution or from a country level, addressing the central bankers. Some areas that really should be focused on are training in technology, the software, and making sure that the software that the organization uses is up to date, the most modern and cutting edge, so that the screening and the searches that they're doing are effective and efficient. Really doing an assessment of whether the manual versus the automated technology being used is effective, and whether there's a better option available, and then ensuring that once that option is identified, that the training is implemented for the individuals who are applying that technology. Areas that would be helpful from a sort of a bigger picture situation would be some internal training on FATF recommendations and why FATF is suggesting these recommendations. And once that's in place, then how is the organization going to implement them? Really, what are they going to do? Create a budget of how they're going to, what the resources they're going to need, and how they're going to implement these recommendations. And do some training on the US Patriot Act, and what are the rules and regulations associated with the US Patriot Act, as well as the Bank Secrecy Act. And talk about possibly the role of examinations and auditors, and really be familiar with the manuals used to conduct these examinations. For instance, the FFIEC, the Federal Financial Institution Exam Council, and the Currency Foreign Transaction Reporting Act. So there's a whole list of areas that should be addressed, and I guess my recommendation would be to create workshops where all of this is encompassed and addressed in very in-depth, at very in-depth levels, and the audience can really be interactive and ask questions and get a real strong understanding of what is expected and then how to do it. So this is, again, areas where I see that needs improvement in the United States, as well as very different multinational organizations across the world, from Spain to every country in Europe that I've dealt with, to Asia, Japan, and so forth. So I found that there's a lack of understanding of what really needs to be done, and a lack of education and knowledge. But I'm happy to answer any questions or comments at the end of the webinar. Thank you.
Thank you very much, Ms. Kelly, for your insightful discussion. Ladies and gentlemen, Ms. Kelly enlightened us on how correspondent banking relationships can be leveraged to combat money laundering and mitigate the associated risks. Now, before I introduce the next speaker to you, I'd like to welcome the President of Center of Pakistan and International Relations, COPAIR Pakistan, Ms. Amna Malik. Ms. Amna, welcome to the session. Ms. Amna is the President of Center of Pakistan and International Relations. She is the President of COPAIR and advocating policies at national level to combat money laundering and terror financing. She's also promoter of equal rights for all, women empowerment, interfaith harmony, and global peace. She's been awarded from the President of Pakistan, Dr. Arif Alvi, and the Prime Minister of Malaysia, Mahathir Mohamad, for extraordinary efforts and contributions for Pakistan. Welcome to the session, Ms. Amna. And now I'd like to call our next speaker, Barrister Hassan Aslam Shad, to share his insight on the subject. Barrister Hassan Aslam Shad has written extensively on the subject, and we'd like to seek the answers of the very unjustifiable discrepancy of FATF's attitude towards Pakistan and India, as we discussed earlier as well, because while the enemy is busy weaponizing the international legal system against Pakistan, a very pertinent question arises whether Pakistan's lawyers and relevant policy makers are ready to cope with this humongous challenge. Barrister Hassan Aslam Shad, the floor is all yours.
Maleeha, thank you very much, and you're very gracious in conferring the title of barrister on me. I wish I was. I did my law education from the US, and although this was something I would have definitely loved to do if I had woken up at the right time, but thanks again for that. Firstly, thank you very much to everyone who has given their very insightful views on this. I think the details have been set out in, comprehensively by all the speakers, and I will just give you my thoughts on this from an international law perspective. I have written on this in the past, and this is something that I have also advised our policymakers in some capacity. So the biggest enigma that we all face is, we ask the question, why did we land in the FATF grey list? Why us? I mean, this is the biggest question that we face, and the answer is not that easy. And when they asked me this question, I frankly thought of it as a question that was to be answered by looking at the law and answering, whatever there was in the rules that we could not comply with. But having studied this in more detail, I have now realized that Pakistan's landing in the FATF grey list in June 2018 has two dimensions to it. The first one is the geopolitical/geostrategic dimension, and the other one is the law and the politics dimension. And it's important to divide into these two dimensions because Pakistan had landed in the FATF grey list in 2012, and we managed to escape it in 2015. And when we again landed in June 2018, we thought that a chapter and verse response, basically a similar response to what we did in 2012, would enable us to get out of the FATF grey list. I think this was a fallacy by our policy makers because we failed to realize that the world had changed significantly between 2012 and 2018. And and because of the changed geopolitical and geostrategic scenario, what was expected of us was different from what was expected of us in 2012. So this was the first thing that I realized when I sort of dived a bit deeper into this question. Second is the law and the politics aspect of FATF, because although FATF is all about rules, as we know, it's all about requirements, it's all about an intergovernmental organization's plethora of rules and regulations that are asked of us to comply with. But at the same time, there is a political element to this as well. FATF rules are, derived from United Nations Security Council resolutions, in particular UNSC resolution 1368 and 1373. So there is a crossover of different regimes, and that makes FATF, not only more potent, but also a bit ambiguous when it comes to getting to the bottom of it and finding out what exactly is happening in terms of requirements that we need to comply with. So going back to the point I made about geostrategic compulsions, I think what changed was that since I would say 2015, America and India have moved closer together in terms of being allies, in terms of their goals, in terms of their economic interests, and that has of course created a added political pressure on Pakistan, which is moving towards the Chinese camp. So I think in a way you can say that the battle lines were pretty much drawn up clearly by 2018, because Pakistan was no longer seen as a neutral party in this. The perception in America was that Pakistan was in China's camp. So this was one of the main reasons behind Pakistan being moved to the grey list, at least in my view. Although having said that, I don't believe this is the sole reason. The other reason that we landed in the grey list was the fact that we did not do our homework. So the world only respects those who know the requirements, who understand the requirements, and then do what is required of them. Pakistan woke up late, and I have been telling the policymakers of Pakistan as well that we should have made sure that we understood the requirements and we started working on complying with those requirements instead of waiting till the last moment. So going back to the UNSC resolutions I mentioned, 1368 and 1373, these two resolutions basically changed the entire dynamics of international affairs and international politics and international law for that matter, because the September 11 attacks basically made non-state actors, come in the eye of the storm. And because of Pakistan's proximity to Afghanistan and the historic relationship that we've had with Taliban and with the other actors for many reasons, more specifically back in the 90s when we were part of the US's late 80s and 90s when we were part of the US camp and we were fighting against the Soviet Union. From that day onwards, we had a relationship. So that relationship that we had was used against us, and we were made to appear as as someone who was not on the side of the international community. This was one of the reasons why we landed in the FATF grey list along with our own faults. If we had taken this seriously initially, if we had understood the requirements, then we would have been able to come out of the grey list, I believe, long time ago. We did not do that. Now, instead of understanding the requirements, the Foreign Office of Pakistan focused on getting a support of friendly countries. I mean, this was the word used in the media, the friendly countries who can bail us out. But surprisingly, the friendly countries were only helping us out in terms of not getting blacklisted. So in a way, our target kept changing. Initially, we were trying to get out of the gray list, but later on, we thought that a victory was our avoiding the blacklist. Now, this was not the kind of response you would expect from a country, which is, a geostrategic pivot, which has been fighting terrorism, which has itself been a victim of terrorism, and which is trying to be in the good books of the international community. So I think the fault was, in a nutshell, our ability to understand the law and also the geostrategic equation that had changed substantially by 2018. Now, what we need to do is something I think which has been adequately answered by the three or four panelists. I think the biggest lesson that we need to learn from this episode is that we need to have a centralized authority in Pakistan, preferably a ministry, that is the pivot for all work related to our international obligations. FATF is one. The others are our international arbitrations, our international cases, where unfortunately we have not done very well. The most recent example is Broadsheet. We are already mired in Recordec, where we have a 5.9 billion penalty. So a lot of this, and I'll go back to what Ms. Kelly mentioned in her talk. She did say that the problem is that, in practice, we are not able to implement these rules. There is a disconnect between the policy and the practice. And these gaps can only be filled up if there is a centralized body, and that centralized body should be the channel for all kinds of communication. It should be the channel for obtaining all kinds of information, and then making sure that the other agencies, for example, the central bank, the State Bank of Pakistan, the SECP, and all other regulators eventually report to it, so that there is no disconnect. There is no mismatch between what is being told to us by the world and what we are ending up doing. This is very important, because if we do not do this soon, then we will continue to be in a situation like this. Another last thought before I conclude, I think the discussion that we are having today, Maleeha, thanks to you and your colleagues, if we had this discussion 2 years ago, and the government was a part of this, and we had experts here sitting and explaining their point of view and telling what needs to be done, if we had had this opportunity 2 years ago, then most probably we would not be in the FATF grey list. With the plenary coming up in February this month, I believe, one hopes that Pakistan is, seen as complying with the requirements of FATF. And if not, then my hope and prayer is that we be given a further chance to ensure compliance, because frankly, despite all that has happened against us, we have still done, a lot since, being on the grey list. We have tried to make amends. We have tried to introduce new legislation. And I don't think Pakistan, should be penalized any further than what it already has been. So with that, I come to the end of my short talk. Thanks.
Thank you very much, Mr. Hassan. Ladies and gentlemen, Mr. Hassan enlightened us on appraisal of FATF assessment dynamics. And there's no doubt about the fact that India does have much greater economic and political clout as compared to Pakistan. And because of this, Pakistan is lagging behind. So there are many other reasons as well, because in this day and age, obviously battle lines are being drawn on socio-economic, political, and legal fronts. Let's not forget the fact that legal front has gained more and more importance. And I absolutely agree with Mr. Hassan that Pakistan has to have this institutionalized lawfare. Pakistan has to have a proper ministry, which not only caters this FATF issue, but also other international arbitrations. Otherwise, we'll keep losing on international front, and there'll be no end to it. So now we'll move on to the question answer session. Mushahid, do we have some more speakers? Is any speaker left?
I think Ms. Amna Malik might wish to share her thoughts
obviously,
briefly.
For sure.
Yes.
Absolutely. How could we forget the woman of the match? We'd like to call Ms. Amna Malik to share her insight on the subject. Ms. Amna Malik.
Thank you very much. Thank you very much for joining this webinar on the behalf of Center of Pakistan and International Relations. We are always keen to highlight important subjects which matter to Pakistan with regards to the national security, diplomacy, trade and investment, and other sectors. We believe that Pakistan should have a very strong national narrative at the international level. And this today FATF dialogue challenges for Pakistan in combating money laundering and financing of terrorism is something very important. I am thankful to Mr. Abdullah, Kalu, Maleeha, Hashmi Saiba, and Mushahid for conducting this wonderful webinar on the behalf of COPAIR. And I'm also thankful to all the distinguished speakers who highlighted many important points. As we all discussed earlier, that this is one of the global challenge for Pakistan to be on one side the part of the global economic order as a world among other world countries on one hand, and on the other hand there is a negative international perspective of Pakistan, especially after this hybrid warfare, that Pakistan is considered to be a threat, and few non-state actors of Pakistan who are playing a negative role is trying to damage our image. So our concern is that we should develop a positive narrative of Pakistan in the international scenario. And these interactive session, as mentioned by Ms. Kelly as well, this is very important because, we can develop the thought process, and through these networking, we can, as Mr. Hassan Aslam Saab also mentioned it, that this is the time our government is in the process of transition of implementation of policies according to the international financial institutions. So this is the time that we need to advocate the policy makers, we need to advocate the implementers, and those who are following the policy, that how the government of Pakistan can play a very important role. And on the other hand, the civil society, we are the civil society, the journalists, the lawyers, the experts who are over here, they can play a very important role. What I believe that we need to connect this as well. So we are planning to publish a complete comprehensive research paper, which we are inshallah going to provide to the policy advocates, and as well as we would like to encourage the civil society, the media, and we need to raise voices that Pakistan is having a very important geo-economic strategic location. You can't ignore Pakistan because it is connecting east to west. So now the dynamics have been changed, and Pakistan is having its own importance. The only thing which is important that because we interacted with the business community, especially while doing our research on this FATF dialogue. So we also believe that our business community needs to be educated, that they need to pay their taxes, they need to use the banking system on one hand, and our government also needs to provide some kind of encouraging policies, like encouraging the banks that people should try to do their transactions through the banking sector. As well as the second point is that people need to pay taxes to get the services from the government. So this realization is required, and for this I think there is a requirement of more awareness sessions, so that there should be some more collaboration of the business community and the government of Pakistan. At the international level, we believe that India is maneuvering through its international players, through its diplomacy, through its economic interactions with other countries, and they are trying to sideline Pakistan. Their wish is to isolate Pakistan, but that's not possible, because now Pakistan geoeconomic importance cannot be ignored. So that is the time that the government should take firm action in this regard. And finally, I would like to thank you, all of you who participated over here, because you are an expert in your field. So we are here to gather the best experts, so that we will be able to provide the platform where we can together work on the positive narrative of Pakistan at the national level and at the international level. Thank you very much, all of you. Thank you very much.
Now,
Thank you, Ms. Amna. Yes,
now that we've heard everyone's illuminating thoughts, I'd also like to thank you once again. Dealing with the question and answers, I think it's fair to say we'll put the questions to all of the panel, and I would like to get the ball rolling by one of my own questions. It reads as follows. Countries in the West, such as the United States, UK, and Germany, are already developed economies. do you think it is fair to subject developing countries like Pakistan to the same stringent financial guidelines as those that are used to regulate developed economies?
Good one.
Can I answer this?
This is to all of the speakers.
Right.
Yeah,
So,
Mr.
look,
Hassan,
I
please
mean,
go ahead.
Sure. Thank you very much. Look, the question has of course, this is a good point that has been made by whoever has asked the question, but you have to understand that since the signing of the United Nations Charter back in the 1940s, one of the presumptions was that all countries are equal. They're all sovereign states and they all are bound by the same laws that are applicable to any other country. So in terms of developing versus undeveloped, unfortunately, you cannot avail this argument and you cannot plead this argument as the basis for avoiding your liability. You will have the same requirements. In the case of FATF in Pakistan, for example, Pakistan has been given several opportunities to bring its house in order. So if FATF was to proceed against Pakistan, strictly or stringently, then it's indeed possible that Pakistan could already have been penalized. So I think at the end of the day, all the countries who are now part of the international community, and they all have to comply with the same set of rules and regulations. And there is no way for a developed country or an undeveloped country to be treated differently.
Thank you. Abdullah, next question, please.
Yes. I'm going to be asking the questions that have been put on the chat box, and just reading one of those. It goes as follows. Money laundering and terror financing are global challenges. Complete transparency is missing everywhere, even in the most developed countries. Will systematic transparency and legislative reforms bring the required results? That's the question.
Yeah, can I just say one?
Historical one.
Can I go ahead?
Yes, please do. Yes.
Yeah. So I think I would just look at it from the issue of corporate transparency, in the sense that shell companies, the issue of shell companies, laundering of money is become a big major issue, and there's a lack of transparency in that. Just said in my presentation, referring to the fencing files, it was a big issue. Like we saw most of it being involved, where you have a situation where companies actually try to, or financial institutions try to onboard companies, and there's little information, being collected there. And we also have the issue of wire transfers. But I believe that, now steps have already been taken, and we see the United States, which the new law was passed for transparency, and I don't know why it just happened now, but at least they have actually taken steps to ensure that the beneficial owners, have to be reviewed, and the UK has already taken concrete steps too. So we are hopeful, although the laws are not actually, they have some loopholes in them, but based on what the steps have been taken, we are hopeful that something will happen. I mean, so long as the cultural compliance is there. But the major, I think, is a very good question, because the major thing that we have to look at is the fact that the enforcement authorities, they need to really take action. I mean, the fencing files showed that there's a lot of issues going on, and it's not just about it's actually coming from developed countries. If you look at the rating, 1% recovery rate in terms of money laundering, in terms of illicit proceeds in general. So it's a big issue, and so if they do not do the fines properly, and people still continue to evade these obligations, and financial institutions are like, okay, yeah, the law is there, but we are still going to, because of the fact that they've been relaxed on the fines, there's going to be an issue. So I think it's going to be very important for the regulatory authorities to ensure that they enforce the actions, and it might have to go beyond just issuing out little fines. They really need to go out there. They really have to start prosecuting the people, like go into the companies to prosecute who is doing this. They need to lift the veil of incorporation. That is exactly what it's so important. So it's not just about the laws. The laws, yes, it's strategic, it's good. We hope for that. But if they adopt this relaxed type of approach, because we saw a lot of situations where the suspicious transaction reports were not even looked at, and sometimes it took a lot of time for them to file the suspicious transaction reports. So it's a big issue. So we hope that at least from now on, there'll be some form of seriousness. Yeah.
Thank you, Eric. The next question is, again, for all the speakers. Is there a possibility that the FATF is being used to achieve political aims such as coercing nation states to follow a certain protocol? Now, I ask this question in the context of Afghanistan. A couple of years ago, I read a book written by the Washington Post writer Joshua Partlow. It was called A Kingdom of Their Own, The Family Karzai and the Afghan Disaster. And in this book, it was mentioned by Mr. Partlow that there used to be millions of dollars in brand new crispy notes that would be flown to Dubai on planes, government planes, and they would not be checked in Dubai. And this was the classic sense of money laundering being engaged by the Karzai family. Why is it that countries such as Afghanistan, TF grey list, is there a reason for that?
You see, there is definitely there is a political element to all this. There is no denying that, because I think it was you who mentioned that Afghanistan and India, or Maleeha mentioned that Afghanistan and India have not landed on the FATF grey list, despite there being many deficiencies in their financial system. Now that makes one wonder, why are they let off the hook, and why is it only Pakistan? So again, most definitely the answer is yes, there is a political element to this. There is coercion. Some time ago, 2 years ago, I had written an article, and the title of that article was FATF and Pakistan, Coercion or Self-Inflicted Wounds. So again, I will say the same thing. It's coercion and it's self-inflicted wounds. It's both. It cannot just be self-inflicted wounds, because if it was self-inflicted wounds, then India, Afghanistan, and many other countries would be today on the FATF grey list. But there is self-inflicted wounds and coercion. So what has happened is, because of our deficiencies, we have been unable to understand the requirements, and because of the changed geopolitical and geoeconomic equation, a lot of politics has corroded the law, if I may use the word. I mean, politics has been used to corrode the legal rules. You do have clear cases of back channel diplomacy happening against Pakistan. This happened at the plenaries. It happened at, on a number of occasions at the time that Pakistan was being called to respond to questions as to why it had not complied with, items 1, 2, 3. So yes, it's a mix of both. It's very difficult to say which is more than the other, but I think it's a hybrid of both of these.
Thank you, Mr. Shah. Thank you very much. This is a question for Ms. McCann, if she's able to assist. Ms. McCann, what is your say on Pakistan's recent progress to comply with the 27-point action plan? Is Pakistan's progress sufficient to enable it to exit the grey list, in your view?
Well, I have not actually gone into depth into the progress that has been made, but I think that any progress that has been observed is a positive sign. Just providing the, examples that they're working towards the action plan and resolving some of the issues is a great sign to FATF and to any other regulators or international observers of Pakistan's progress. So I can't answer to that specifically because I haven't gone into depth with regard to the progress that Pakistan has made on FATF recommendations, but I do believe that any progress is good progress, and that it proves that they're committed and dedicated to improving the systems and so forth. But I would like to take this opportunity to quickly comment on a previous question, and I think that that more international cooperation and communication and collaboration is needed in order to combat any of these issues, because a lot of the money laundering and terrorist financing are cross-border. And so really providing more forums where they can share information across borders and share investigations is crucial to either identifying the individuals that are executing the crimes or really trying to apply law enforcement across borders to identify where the crimes are taking place and what tools and resources they're using in order to accomplish their illicit crimes and so forth. So I think that FATF could provide greater guidance and trainings either at a more visible level and more often, or other regulatory bodies provide, greater forums to share this information to really have a stronger international push to combat these issues.
Thank you very much, Ms. McCann. We're just coming close to the 8 p.m. mark. May I take this opportunity to...
I have one question from Ms. Kelly, if you allow me.
Yes, go for it.
Thank you so much, Ms. Kelly, for such an extensive analysis on the corresponding banking. You spoke about the usage of digitalization in the banking system. So if you consider the third world states that are in nascent stages of digitalization, and the Western world is quite developed in that sense, so do you think that FATF can design a criteria on the disparity level rather than the uniformity for the states while assessment of their cases who are in compliance with money laundering and terror financing?
Well, I'm not sure what exactly FATF is able to do with that regard, because I am not a FATF employee, although I would suggest that they look into it. With regard to the disparity between developing countries and developed countries, I feel that similar to what Hassan shared, is that there's laws that everyone needs to abide by, but I think that overall they're ideals. So no country is perfect and no country is 100% innocent. And so as long as the countries, including the developing countries, are striving towards those ideals and making progress towards the regulations, that I think that that's a great sign for FATF and other regulators and international bodies to see progress. And as long as progress is made, it shows dedication and commitment to improving systems and so forth. So I think back to the communication component, as long as the Pakistan or any other country is communicating regularly with FATF and asking questions or seeking guidance, I think that shows that they're committed to improving the system, and it can only bear fruit in the long term.
Thank you so much. I have a very short question. I have another very short question from Mr. Hassan Aslam Shah. Sir, is there any, do you think legal or reformative status vis-a-vis concerning the disinfo lab revelations? Can Pakistan pursue a case in International Court of Justice in this regard? Because
no, firstly, we cannot go to the International Court of Justice because of the 1974 declarations made by India and later on as well. We cannot go there. And the second thing is that the unearthing of this EU disinfo lab report, as much as it makes India, at least the state in my view, liable for all those activities, despite this, we have to understand something, that just because something bad is happening in India or they are guilty of something bad does not automatically make us look good. So we have to do our bit to get out of our mess. So the EU disinfo lab report thing is important on its own, but it does not lend us a hand to get out of our other problems that we are facing with FATF. These are two independent issues. We should not link them. And even if we try to link them, I don't think we have the leverage, internationally speaking, to take India head on, because India has, a soft power. They have done, they have invested in, building a narrative. We, for the first time in the last 2 years, we have actually woken up and we've started telling the world our story. Before that, there was no story, right? So you can't expect things to change overnight. It's something that we want the world to look at, and we are trying to do our best, but that in itself will not, extricate us from the FATF mess or give us the opportunity of taking India internationally to, institutions as such.
Thank you, Mr. Shah. We have now finished our allotted time. May I take this opportunity to thank all of the distinguished speakers Ms. Amna Malik as well, and Ms. Maleeha Hashmi, and Mr. Mushahid Naqvi for arranging this informative seminar. Thank you all once again, and I would like to wish you a very good weekend. Thank you.
With this, I would just conclude. With this, we came to end of this conference. The webinar presents a critical appraisal of the FATF role in combating money laundering and terror financing. We will compile the recommendations provided by the worthy panelists and share it with the relevant departments of the government and non-government institutions, and it will help the policymakers to address the challenges emerging from money laundering and terror financing, and its incorporation in decision making, especially with the compliance to FATF protocols of Pakistan. With this, I conclude the session, and thank you all of the panelists on the behalf of COPAIRs for their utmost time out of their busy routine, and we will look forward for the further collaborations. Thank you all. Pakistan Zindabad.
Thank you.
Thank you.
Thank you.
Bye.
Bye.